In this video, I'm going to kind of give you a little child custody 101. Okay, I'm going to go through some basic legal terms that are used in court. A lot of people are confused on these, even once they're pretty far into the process. I'm surprised a lot of times. They're going to kind of talk about that a little bit. But before I dive in, let me just remind you, as always, if you like this content and you find it helpful, don't forget to hit like on this video. Also, subscribe to the channel so that you get notified as new videos are released. When you're going to go into court on child custody, it's really important that you understand some very basic terms. And I think one of the most misunderstood is legal custody versus physical custody. And this is called different things in different states. And I think it's part of why it becomes kind of confusing. Legal custody is usually something that's what it's called across the board most of the time. Okay. I don't know that I've ever really heard a lot of other terms for it. I think the physical custody is the thing that we get confused on because, people will say, I want primary custody, which means they want the vast majority of it. Or a lot of times when people say, I want sole custody, it's like, okay, well, are you talking sole legal because you want to be the decision maker, or sole physical because you want the child 100% of the time? Okay, so we have to be clear on what those terms are because the court separates those two issues out. Many people have joint legal and still might have 50-50 on legal and might have, 70-30 on physical or whatever. So they're two separate things. Okay, so let's talk about what legal custody is first. Legal custody essentially is decision making. It has to do with medical decisions, school decisions, health, safety, and welfare types of issues, okay? Dental appointments and all of those types of things fall under therapy. Any of that falls under legal custody issues. So vast majority of the time, people are going to have joint legal, in my experience. You do sometimes have one person that has sole legal. A lot of times somebody's incarcerated, or, one parent just isn't really involved, or that's what the parties agreed to, different things like that. Physical custody just refers to where the child is going to live, okay? And some people just call this, some courts just say the parenting plan, okay? That's your physical custody, your parenting plan. I also have times where I've heard it called primary custody, okay? Which means like one parent has a higher percentage of parenting time. And when you ask for things like sole custody on the physical side, I don't think that looks good to the court because you're essentially saying, I want 100% of the parenting time and I don't want the other person to have any. And it's like, well, if you're even asking for the other parent to have every other weekend or anything at all, then you're essentially not going to have sole physical custody. Okay. So it's real important to separate out those two issues and be clear on what you're asking for, because you don't want to give the court that you're trying to push the other parent out in some way, or that you don't regard the other parent's role as important, or anything like that, because that usually works against you. One of the things that I think is also very confusing is best interest of the child. Now, people tend to think of this in kind of layman's terms, where they go, well, best interest of the child is anything that I think is good for the child, right? Like, oh, it's in the best interest of the child to eat an apple versus a candy bar, right? I think we would all agree that eating an apple is probably healthier than eating a candy bar. But that's not in the best interest of the child in the court's context of what best interest of the child means. Okay, so you have to understand that best interest of the child is a legally defined term. And if you go Google it for your state and look up what it means, what it will actually say is things like the child has an interest in having an ongoing relationship with both parents. The child has an interest in their safety being protected. The child has an interest in having access to education, the extent to which one parent supports the other person's parenting, all those types of things. That's really what best interest of the child means. It doesn't mean a parenting thing that I think is better. Okay, that's good for your kids, but that's not a legally defined best interest of the child. And I think that's one of the big mistakes that people make. So Again, important to know your different terms. Parenting plans. This is another thing that comes up. People don't understand that different parenting plans are considered appropriate by the court for different ages. If you go in and ask for a week on, week off schedule for your 2-year-old, you probably are not going to get that out of the court because they're going to see that as an inappropriate thing based on the child's age and based on their emotional development, right? The stage that they're at in life at that point, that's too long for them to be away from a primary caregiver. So again, if you're going in and asking for things that are kind of a complete non-starter, then the court's kind of like, okay, you didn't really take your child into consideration. You're just putting out there what your wishes are. And unfortunately, the court doesn't really care what our wishes are. They care what's in the best interest of the child. And so you have to be able to give very child-focused reasons for why you're asking for these things. And if you don't even understand the basic definitions of them, then you can't, okay? And a parenting plan is essentially just the schedule you're asking for, whether that's week on, week off, whether that's what we call a 2-2-3. Excuse me, I have a little bit of a hiccup. Whether that's what we call a 2-2-5-5. Okay, there's different schedules every other weekend and a weekday overnight. You need to familiarize yourself with these schedules. You need to understand what's appropriate for the age of your child and also what can be implemented logistically. If your child is a teenager, then a week on, week off plan is totally appropriate. But if you live 6 hours apart from the other parent, well, that's not really logistically possible. So the court looks at all those different aspects of it to try to determine what parenting plan is most appropriate. Okay. The other thing that happens is I think people don't understand about trial. When you initially go to court for a custody or divorce or whatever, most of the time, what we call a motion is filed. Okay. And a motion essentially means court, we don't agree on this issue, whether it's custody or support or whatever the issue is that you're having disagreement on. And we're asking the court for help in making a decision on this issue. Okay. And then the court will set a hearing. And then you go in and you have your motion hearing. Now, if at that motion hearing, there is some reason that either one of the parties or attorneys or the court feel like, you know what, we don't have enough time, because a motion hearing is usually 30 minutes, give or take, 20, 40. It's different in different jurisdictions, but about in that ballpark. If the court doesn't have time because somebody wants to put on all these witnesses or do all these things, the court's going to go, okay, I'm going to set you for a trial. And people, that word tends to invoke a lot of fear for people. Sometimes it's called an evidentiary hearing, sometimes a long cause hearing, or a trial. It can be referred to as any one of those. Trials usually mean half day or longer. Evidentiary or long cause hearing usually just means it's less than a half day. It's a couple hours. Okay. But it's the same process. Essentially, it's just a matter of how long it's lasting most of the time. And an evidentiary hearing a lot of times also is applying to the temporary issues, which means the motion issue that we're just having trouble with right now. We're asking the court to give us an order pending final resolution of the whole case. Okay. So you can go to trial or have an evidentiary hearing on just custody. If you go in and you have a disagreement on custody and there's all these extenuating circumstances and the court wants to have an evidentiary hearing to get more information about custody, you will still most of the time come out of that hearing with what we call temporary orders, which means your case isn't finalized yet. You're still going to have to go through and get final orders. Okay. And I see people sometimes go to trial again on final orders, but most of the time, once you go to trial on it on a temporary basis, usually that's the order that becomes adopted for the final. Hopefully you reach agreement and you're able to kind of move forward at that point. You have to start understanding some of these processes and procedures and core things around custody. And honestly, if you're self-represented, obviously these things are critical because you're trying to conduct your own case. But even if you have an attorney, it's important for you to understand these differences because your attorney needs different things from you on different timelines and at different levels, depending on what's happening within the context of the court system and what they're trying to accomplish. So when you can start to understand what they're up against or what the court is looking for or what they need, then you are better able to provide your attorney with the relevant information in an efficient manner, which helps you save on cost and enables you to have more success in your case because you're actually giving the attorney information that they need. I hope those few tips are helpful. There's hundreds of things of that type of information that, I wish I could just download into my brain to you, but it would probably be overwhelming. And so hopefully those core things at least get you started down the right path. But if you'd like more help and to be able to learn more about these types of concepts, you can go to divorceuniversityonline.com/VIP-coaching. There's information on that page on my group coaching programs for moms and for dads. And there's also information on my one-on-one VIP coaching services. If you have a more complex case, or you're right at the very beginning, or you just kind of need a higher level of support, then that might be the better option for you. Thanks for joining me, and I'll see you guys next time.